The California Labor Code provides you as a California employee many protections, probably more than any other state in the country. The area of law that we call wage and hour litigation involves many different categories because the Labor Code provides so many protections. Some of those categories include making sure that you are paid the legally minimum wage for the work that you do. It involves whether you get overtime. And for a non-exempt employee, you're entitled to overtime premium anytime you work more than 8 hours in a workday or more than 40 hours in a work week. It involves issues such as whether you're given proper meal or rest periods. As a non-exempt employee, you're entitled to a meal period of 30 minutes off the clock anytime you work at least 5 hours a day, and that period of time must be duty-free and uninterrupted. As to rest periods, a non-exempt employee is entitled to a rest period of 10 minutes on the clock that must be duty-free and uninterrupted every time you work 4 hours or a major portion thereof, and for every 4 hours that you work on the job. The Labor Code also provides protections that gives you the right to certain types of wage statements, the retention of records and your access to your records, and even proper seating in certain circumstances. This wage and hour area of law also includes major issues of misclassification. Many times we find that people are classified as an independent contractor by employers who want to avoid paying certain matchings that they're required to pay to the various government taxing authorities, or they want to avoid paying workers' compensation. And so they characterize an employee as an independent contractor inappropriately. In other situations, we find employers who wish to characterize an employee as exempt, meaning exempt from the rules of overtime and minimum wage and meal and rest periods, when they really are not an exempt employee. Most of these wage and hour issues can be dealt with on an individual basis, but oftentimes it's dealt with as a group. That means that many of these cases involve multi-plaintiff claims or claims brought under the Private Attorney General Act, where one or more employees stand up and seek penalties, standing in the shoes, so to speak, of the Labor Commissioner for violations done to all of the employees of the company. And these types of claims are often also addressed through class action litigation. It can be a very complicated area of law, and you have multiple venues that you can go to address these issues. So my suggestion is for you to find an attorney and consult with them confidentially to determine what your options may be, but do so quickly because there are deadlines and you don't want to miss the deadline.